And I love them, and they're coming out to help me again. We've already organized it.
All right.
Yeah.
Testing.
Right now we're doing petitions, and I have to worry about everything.
Testing, testing, 1, 2.
Rules Committee will come to order, and thank you very much for joining us this afternoon. Today, the Rules Committee will handle a very important piece of legislation, and I want to make sure that we run through how we're going to proceed this afternoon. It's slightly different. We're going to handle the original jurisdiction part, and then we'll handle the Rules Committee part. So we're going to start with original jurisdiction hearing, which is what we have before us right now, where we'll hear testimony from our invited witnesses on HRS 639, authorizing the speaker to appear as an amicus curiae on behalf of the House of Representatives in the matter of the United States et al. Versus Texas et al. We will then move into an original jurisdiction markup, followed by a consideration of a rule for floor consideration that would be tomorrow. A reported 25 states or more or state officials have filed suits challenging the administration's expansion of DACA and the creation of a DACA-like program for aliens who are parents of U.S. citizens or lawful permanent residents. On February 16, 2015, the U.S. District Court for the Southern District of Texas entered, and the U.S. Court of Appeals for the Fifth Circuit affirmed a preliminary injunction prohibiting further implementation of these programs on the grounds that the states are likely to prevail in their argument that the programs ran afoul of the United States law. The Supreme Court indicated that it will begin hearing oral arguments on the U.S. v. Texas in April of 2016, and that it will consider the plaintiff's claims under the and including the Take Care Clause. Because of the timely consideration by the High Court, the Supreme Court of our land, it is imperative that the House consider this resolution that we are having today. I want to make clear that this resolution is not about policy. If you spoke to every member of this body, and I'm sure many of us speak to each other and we're well aware of not only dissenting views but different ideas that we have, you would find a wide spectrum of opinions regarding how to handle the estimated 11 million illegal immigrants currently residing in the United States unlawfully. This resolution is not about those viewpoints. It is about the fundamental separation of powers ingrained in our founding document. Article 1, Section 8 gives Congress, not the President, the authority to, and I quote in here, to establish a uniform rule of naturalization. Directly out of what we believe is our constitutional authority. The administration cannot simply ignore certain statutes, selectively enforce others, or bypass the legislative process to create law based upon executive fiat. That's what the lawsuit's about. The President of the United States has failed in his duty under Article 2, Section 3 of the Constitution of the United States to take care that the laws be faithfully executed. And the Supreme Court has specifically indicated that it will consider the plaintiff's claim under the Take Care Clause, which was a part of what the filing was about. And I will enter into the record that information based upon the request from the Supreme Court. Clearly, the court views this case as an important review of Article 1 and Article 2 and the balance of power between the branches. For that reason, and that reason really alone, the United States House of Representatives is uniquely suited to speak to this underlying question raised by the court. I would like to thank two thoughtful members of the House Judiciary Committee, and in particular, those that serve on the Immigration and Border Security Subcommittee, the gentleman, Chairman Gowdy, Trey Gowdy, who is from South Carolina, and Ranking Member Zoe Lofgren, who is no stranger to the Rules Committee, providing detailed information, thoughtful articulation of her position and policies, and I welcome both of you today for joining us before the Rules Committee. We have thought that perhaps Congressman Gutierrez from Illinois might join us. If he does, he will be added to this panel. Without objection, anything that you have in writing will be inserted in the record. Both of you are important to this hearing today. I value both of you very much. And before we defer to this panel, I would like to defer, if I can, to the gentlewoman, the ranking member of the committee, Mrs. Slaughter, for any comments that she would choose to make. The gentlewoman's recognized.
Thank you very much, Mr. Chairman. I would like to make an opening statement. I appreciate what you said, that we're only here doing legislative business, but I think by now the American public understands pretty well we don't do that. The House majority can't agree on a budget. I just heard presidential candidate Kasich, who was a budget chair here, deploring that on television, and I agree with him. Took vote after futile vote to kill Obamacare, wasting millions of dollars and thousands of hours. Had hearing after hearing, trying to find something happening in Benghazi, although most of the chairs that had it in their purview have said there's nothing there. Have another select committee, again, spending millions of dollars investigating Planned Parenthood, when a case in Texas not only exonerated Planned Parenthood, but indicted the two people who took the films on which everything you've been doing here has been based on. So we know what this is, but today I believe the crusade against President Obama has reached new heights. This resolution surrounding United States versus Texas adds to the already overwhelming list of baseless political tactics that the House majority has used to discredit, to undermine, and to disrespect President Obama. This resolution makes a political statement, one that represents the House majority, not the entire House of Representatives or the entire Congress. The resolution seems to put the whole chamber on record when there is significant vocal and strong opposition to that. In fact, 188 House Democrats, along with 40 Senate Democrats, joined together for our own amicus brief in support of the President's executive actions. Not only were the President's actions constitutional, they are in line with decades of bipartisan action by presidents on immigration, including action by Presidents Ronald Reagan and George H.W. Bush. This is a rarely seen ploy, seeking to file an amicus brief as the whole House, and I'm sure American people will see it for what it is. It's pure politics, and shows us once again that the majority is willing to prioritize their party over their country. Adding insult to injury, Speaker Ryan has said, and I quote, "The president is not permitted to write law. Only Congress is," end quote. How true that is, and why don't we, the Congress, do what we were sent here to do and write the law? In fact, had we taken up the law that we requested to time after time, that the Senate passed in the last term, we would not even be here today. This would be absolutely moot. But what we do now is the majority reaches into their toolbox to find something that isn't there on the Constitution, so they run to the courthouse. Rather than allow the Congress to do the job it was elected for, Republicans insist on telling the other branches of government how to do theirs. It is quickly becoming clear that this is a dangerous moment in our country and in our political system. The Republican presidential primary field is resorting to demagoguery and nativism, fanning the flames of dangerous anti-immigrant anger and anger in general. What the president rightly called, quote, vulgar and divisive rhetoric, end quote, in the Republican contest is a logical and foreseeable consequence of the anger and fear carefully and deliberately cultivated by decades of campaign strategy as the Republicans went beyond principled advocacy for smaller government to the outright encouragement of people to believe that government is their problem and an enemy to be hated. In an effort to delegitimize President Obama, they indulged conspiracy theories about our first African-American president being a foreign-born, quote, secret Muslim, end quote, who aspires to be a dictator and take away all of our freedoms. And capping what the New York Times editorial board characterized on March 15 as, quote, decades of pandering to intolerance, end quote, hateful words have been used to describe Latino immigrants, among them, quote, calves the size of cantaloupes, end quote, calling them wetbags, dogs, livestock, end quote, and saying they come from, quote, a violent civilization, end quote. These things were done and said to win elections and score political points, but they've helped prime the electorate for this year's candidates. This debate would not have been an issue if last year the House took up the bipartisan Senate immigration bill. That was an opportunity for our country to come together instead of further dividing us. And we want to make it very clear on our side that we know what this is when we see it, because we've been seeing it often enough. And that this is not something that the entire House of Representatives believes is either right or proper. And I yield back the balance of my time.
Thank you very much. The gentlewoman's comments are appreciated. I'm glad the gentlewoman did refer to the amicus brief that was filed by most of the members of 186 members of the U.S. House of Representatives and 39 members of the U.S. Senate as their amicus brief. It has helped fuel.
Would the gentleman yield just on that one point? Those are almost precisely the numbers, given one on either side, of the Democrats on the other side who filed a different one, and the 40 members of the United States Senate. So the point I think is very well made that you just made, that this is simply the Republicans' idea to do this, that the Democrats are not indulging in it. Thank you.
So I want to acknowledge that, in fact, this had been done by Democrats, as you had spoken of. And without objection, I would like to enter that into the record also, and thank you very much. The opportunity for both of you to be here is to enlighten us on your ideas about not only what we're doing here today, but the practical effect of this legislation is. And Chairman Gowdy, I want to welcome you to the Rules Committee. The gentleman is recognized.
Thank you, Mr. Chairman. I want to thank you for the opportunity of appearing before this august committee, particularly with my friend and colleague from California. Mr. Chairman, the thread that holds the tapestry of our country together is respect for and adherence to the rule of law. The law is the single greatest unifying and equalizing force that we have. The law, Mr. Chairman, is symbolized by a blindfolded woman holding nothing but a set of scales and a sword, because the law is simultaneously both a shield and a sword, and it is the foundation upon which this republic stands, and quite simply, it is what binds us together. So attempts to undermine the law via executive fiat, Mr. Chairman, frankly, regardless of motivation, are detrimental to that foundation. In 2014, President Obama announced his plan for one of the largest extra-constitutional acts ever presented by a chief executive, and he declared unilaterally almost 5 million undocumented immigrants would receive deferred action under some newfangled definition of prosecutorial discretion. In addition to using discretion as a license to rewrite the law, he also planned to confer affirmative benefits, such as work authorization and lawful presence. You may like the policy, Mr. Chairman. You may wish the policy were the law, but one person does not make the law in a republic. If you enjoy a single person making the law, you should perhaps investigate living in another country, because that is not the country that our framers gave us, nor have generations of our fellow citizens fought for, served in, and sacrificed for a single person to unilaterally make the law. The president has recognized, Mr. Chairman, on his own initiative 20 separate times that he lacked the power to do exactly what he did. In 2011, he said, and I quote, "The notion that I could just suspend deportations through executive orders, that is just not the case." And he told us time and time again, Mr. Chairman, that he was not a king. Now, his position may have changed, but the Constitution has not. The president can veto a bill for any reason or no reason. The president can refuse to defend the constitutionality of a statute, even a statute that he signs into law. He can issue pardons for violations of the very laws that he signs into existence, and he has prosecutorial discretion as evidenced and used through his U.S. attorneys. Mr. Chairman, that's a lot of power, but that amount of power apparently is not enough. What he cannot do is make law by himself. That is the responsibility of the Congress, and if this president's unilateral extra-constitutional acts are not stopped, future presidents, you may rest assured, will further expand the power of the executive branch, threatening our constitutional equilibrium. And Mr. Chairman, I use that phrase because that is exactly what is at stake in this case, constitutional equilibrium. The same Constitution that provides that Congress shall pass law requires the chief executive to take care that the law is faithfully executed. And the facts at bar, both of those constitutional precepts are at issue. The district court, as you know, Mr. Chairman, issued a temporary injunction against the administration's plan. The injunction was based on the fact that the administration violated the law in its haste to allow others to violate the law. The administration appealed and sought a stay before the Fifth Circuit Court of Appeals, and the Fifth Circuit denied both requests. For too long, Mr. Chairman, Congress has stood by while the executive branch has engaged in a variant of constitutional adverse possession. The president came on the floor of the People's House and said he would do it with or without us. With all due respect, he cannot and will not and should not do it with or without us. The House has the standing to bring this suit, but instead the states did. And since the House has standing to bring the suit, of course, it has standing to weigh in on the briefs. And Speaker Ryan is correct to do so in this fashion. Today, Mr. Speaker, it will be immigration. Tomorrow, it may be the criminal code, and then it will be something else. And I caution all of my friends, today you may benefit from the non-application of the law. Tomorrow, you will cry out for the law to be enforced. And once weakened, it will not be repaired. So the House not only has a right, Mr. Chairman, but quite candidly, an obligation to stand up for itself. And frankly, I think we ought to do it more often. And with that, I would yield back.
Chairman Gowdy, thank you very much. Ms. Loughran, welcome. We're delighted that you're here. Gentlewoman's recognized.
Thank you, Mr. Chairman.
Yes, ma'am.
The committee is meeting on this immigration resolution. I suspect tomorrow we will have a vote on the resolution, which I think is ironic because we never got a chance to vote on the bipartisan immigration bill in the last Congress, which would have made all of this moot. Now, our immigration system is badly broken. Millions of families face the threat of separation by deportation every day, parents from their children, husbands from wives. Whole economic sectors like agriculture rely on immigration, and in fact, in the case of agriculture, undocumented immigration. And in turn, all Americans rely on their work to put food on our tables. We would all benefit from a better immigration system. And over the years, I've worked closely with Republican colleagues to craft immigration reform bills, bills that took a different approach from the Senate in many ways, but were built around a framework designed by conservative Republicans in our group, who I grew to admire and respect. But for years, we've only had talk, we've never had action, and unfortunately, this resolution, which notably has no substantive findings and makes no legal argument against the executive actions, is more of the same. Now, going back to President Eisenhower in the 1950s, every president has exercised the same or similar authority in the immigration context as President Obama did in November a year ago. This authority stems from the president's constitutional duty to take care that the laws be faithfully executed. In Heckler versus Cheney, the Supreme Court explained that this duty does not require the president to act against every technical violation of the law. And when the Supreme Court in Arizona versus the United States struck down most of Arizona's SB 1070 law, the court specifically affirmed that, quote, the broad discretion, unquote, exercised by federal immigration officials extends to whether it makes sense to pursue removal at all. In 1999, members of Congress from both parties, including several people on the Judiciary Committee today, urged then Attorney General Janet Reno to issue specific instructions to agency personnel to guide the use of prosecutorial discretion. And a few years later, Congress, when we set up the Homeland Security Act of 2002, specifically directed the Secretary of Homeland Security to establish, and I quote, national immigration enforcement policies and priorities. Since we appropriate only about 4% of what it would take to actually remove all of the undocumented people who are in the United States, it is necessary to figure out who is going to be removed. And we charged the Secretary of Homeland Security to make those decisions, to set the policies and priorities, and that is precisely what he did. In November of 2014, he followed our instructions that we delegated to him the authority to do this, and he did exactly what we told him to do. It's also instructive and important to note that the Family Fairness Program, a precursor to the most recent executive actions, are a guide. President Reagan's Family Fairness Program was announced at a 1987 hearing before the House Immigration Subcommittee. What it did was it provided protection from deportation to certain spouses and children of persons who were legalized in the 1986 Act. It's worth noting that in the committee report, which I entered into the record in the Judiciary Committee hearing just this week, last week, that the committee and Congress had specifically provided that the spouses and children be excluded from relief. But President Reagan and President Bush instructed the INS commissioner to provide relief anyhow. As many as 1.5 million people would be eligible from protection from deportation and provided work authorization. 40% of the unauthorized population at the time, approximately the same percentage that would be affected by DAPA and extended DACA under President Obama's action. Explaining his decision to expand the program, then INS Commissioner McNary stated, quote, it's vital that we enforce the law against illegal entry. However, we can enforce the law humanely. To split families encourages further violations of the law as they reunite. Commissioner McNary, along with President Reagan and Bush, understood that a smart enforcement strategy can also be a humane enforcement strategy. The President's actions are lawful. They're also smart because they will allow DHS to focus limited resources on serious criminals, gang members, and recent arrivals. They encourage law-abiding, low-priority, undocumented immigrants to come out of the shadows, submit to a background check. Moreover, they're consistent with basic American values like accountability, family unity, and compassion. This matter is firmly in the hands of the U.S. Supreme Court, which will ultimately decide whether the administration's programs can take effect. No matter what happens, however, the responsibility to fix our broken immigration system falls on our shoulders. Only if we approve deporting dreamers and the parents of American citizens should you support the resolution without offering a meaningful alternative. Now, I note that the resolution on page 5, the first page, lines 5 and 6, suggests that the position should be in opposition to the president's executive action. But there's no details listed in this resolution. There's no rationale. There's no reason. And so I'd like to offer an alternative to the resolution before you, an amendment in the nature of a substitute, if you will, or an alternative. And that is the amicus brief signed by 186 members of the House and 39 members of the Senate that was filed with the Supreme Court on March 8th. Now, this goes through, and I'll tell you, I spent a lot of time on this. We went to the Ethics Committee to make sure that we were able to accept the donation of the outside counsel to write this. I worked on this myself because I never sign on to an amicus brief unless I've read it and agree with it. We sent it to every person who signed this amicus brief, and I know that members read it. And as a matter of fact, one of my colleagues from Pennsylvania pointed out that there was a typographical error on page 39 at the bottom of the page. So I know that people paid a lot of attention to it, and I think that they should. But that is denied members in the case of the resolution that is before you. In fact, there are many Republican former members of the House and other elected officials who joined in amicus briefs that have been filed in support of the administration's position. For example, former Senator Richard Lugar, former Representative Jim Leach, former Representative John Porter, and former Representative Ray LaHood stated following in an amicus brief filed with the court last week, quote, "There is no question that the enforcement priorities established by the administration are lawful and consistent with guidance provided by Congress. Based on experience in Congress, amici are familiar not only with the discretion that members of Congress of both parties have embedded in the nation's immigration laws, but also with the manner in which presidents of both parties have exercised that discretion. Amici note that the practice of deferring removal of certain individuals when doing so facilitates the nation's immigration enforcement priorities is a long-standing manifestation of the executive branch's responsibility to enforce the nation's immigration laws that have been deployed by presidents of both parties." And I would note that goes back many, many decades. Now, rather than following up with this resolution that has no meat on the bones and blocks an action that's lawful and helpful to the country, I would say join me. Put our resolution in order. Let's work to craft not only this resolution, but legislation that fixes our broken immigration system. And just one final note. I've been advised that the substitute that I'm offering may not be germane because it's under the jurisdiction of the Judiciary Committee. Well, in fact, even though this is original jurisdiction in the Rules Committee, the substance of the resolution before you is also the subject of the jurisdiction of the Judiciary Committee. And so if there is an issue, you're the Rules Committee, waive any rules relative to germaneness, make sure that members have an opportunity to read the amicus brief and join with us in making our immigration laws more humane. I thank you, Mr. Chairman, for your attention.
Thank you very much. Ms. Lofgren, are you a lawyer?
I am.
Why do you think the president stated before that he did not have the jurisdiction, the authority to do what he ended up doing?
I cannot put myself in the mind of the president. I do not know, and I think in some cases the press statements I've been advised have been taken a little bit out of context. But I'll say this, if I stood up and said the Judiciary Committee lacks the jurisdiction to amend the law, I would be incorrect. And I know that he was a professor of constitutional law. I am a former professor of immigration law, and I do know that he had the ability, the legal ability to do exactly what he did, and in fact, many former presidents did precisely the same thing.
Mr. Gowdy, are you a lawyer?
Not much of one, but I did finish law school. Yes, sir. Had a very mediocre legal career.
Do you possess a law license?
Yes, sir.
Are you aware of the president being a constitutional expert?
I have heard him described as one. I have not heard him describe himself as one, but I have heard him described as I think, actually, the late Justice Scalia, during one dinner, said he was actually an instructor as opposed to a full professor, but that may be a difference without a distinction.
I think that might be. Are you aware that the president has had his his actions overturned by the Supreme Court 9-0 in the National Labor Relations Board action that the president took?
Yes, sir. Those were recess appointments, and it is very difficult. I do want to give the president credit for something. It is difficult and almost impossible to get the 9 members of the United States Supreme Court to agree on anything, but they agreed that he was wrong.
Did they agree he exceeded his constitutional authority?
He did. They did agree because he did. The Senate and House determine when they're in recess. The executive branch does not.
Do you believe that the President of the United States will receive a fair hearing at the Supreme Court, or do you believe that his previous actions would be held against him?
Oh, no, he'll certainly receive a fair hearing. And I will say this, Mr. Chairman, you know, the president started off as a senator, and he railed against executive overreach when he was a senator. In fact, that was one of his planks of his campaign platform, is that the President Bush had exceeded the constitutional boundaries. So I think the 22 times he said he couldn't do it, he was right. The one time somebody convinced him he could is while we're headed to the Supreme Court.
So you believe the President of the United States has an equal chance to be treated fairly by the Supreme Court in his positioning?
Well, he picked 2 of them, so I think those 2 are going to certainly be fair to him. I mean, I don't want to get into who picked who, but he certainly got a fair hearing with what we refer to as the Affordable Care Act.
Thank you very much. Mrs. Fox?
Thank you very much, Mr. Chairman. I'm sorry I was not here earlier to hear our colleagues' comments, but I do want to make a statement about this resolution. On the merits of the case, I very much oppose the President's amnesty programs. I think our immigration system is in need of reform, but starting the process by rewarding first those who've broken the law is unconscionable, more so when you consider the number of people waiting to come to this country legally. But what is of equal concern to me, and what should concern all members of the House and Senate, is the process by which the President usurped the lawmaking authority of this institution. The U.S. Constitution establishes 3 distinct and co-equal branches of the federal government, granting powers to each branch, but also limiting those powers through a system of checks and balances. Whenever I speak to any kind of group, practically, I get out my pocket copy of the Constitution, and I go to Article 1, and I read Article 1, Section 1 to people. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And I point out particularly to students that the Constitution is very carefully drawn. The founders wanted the Congress of the United States to be the most powerful institution. The framers granted to Congress, and we can read it right there in very plain language, to the House of Representatives and the Senate the power to make laws through a deliberative and occasionally contentious process, which we've all seen. There have been times in the past when Congress has not been able to agree on a single law or policy. Happens all the time. While many disagreements fall along party lines, they can also exist between the 2 chambers or among members from different regions of the country. On this issue, the President has frequently claimed he was compelled to act by Congress's inaction on the issue of immigration. However, I agree very strongly with Mr. Gowdy that I think the President was right when he said he had no authority to do what he did for 22 times. And I don't think that disagreements that result in congressional inaction provide to the executive branch any authority to assume Congress's lawmaking power or to override Article 1, Section 1 of the Constitution. That power is not granted to him from inaction of the Congress. That's why I've signed on to 2 amicus curiae briefs in support of the state's case as it's worked its way to the Supreme Court. And I am sure, even though I didn't hear Mr. Gowdy speak, that I would agree with other things that he has said before I got here. And I very much support the action we're going to take on this here in the Rules Committee, and I hope on the floor tomorrow. So thank you, Mr. Chairman, for allowing me to make those comments.
Yes, ma'am. Thank you very much. Mrs. Slaughter.
Thank you, Mr. Chair, and I thank both of you for being here. I know that both of you are thoughtful members who spend a good deal of time on what you're doing. I'm just going to let my opening statement stand. I continue to feel it's a shame that we're doing this in any regard. So many things that need to be done in America, and that we simply can't take any of it up. And I think we're finished for the day now. What is it? 20 minutes to 4. Thank you very much.
Yes, ma'am. Gentlewoman yields back her time. The gentleman from Louisville, Texas, Dr. Burgess.
Thank you, Mr. Chairman, and thanks to our witnesses for being here. Thank you for your thoughtful presentations today on what I consider to be a very important issue, because Judge Hannon is a judge in Texas, in the Lower Rio Grande Valley sector and of the border, and that is an area that's has been under considerable stress because of the crossings of unaccompanied minors and family units. The numbers that trended down just a little bit for the end of calendar year 2014 then have spiked, and spiked rather dramatically. Because I'm also on the Energy and Commerce Committee, because I have the Department of Health and Human Services under my jurisdiction, a branch of the Department of Health and Human Services is the Office of Children and Families, and specifically the Office of Refugee Relocation. And I have been very concerned about, number one, their ability to handle the crisis in which they are involved. But I will also tell you, from being a member of the Helsinki Commission, we heard testimony last fall, very compelling testimony from 2 individuals who were trafficked by family members. And I found this particularly disturbing, and then the Senate had a hearing where it turns out that the follow-up from these 2 federal agencies on children that are placed around the country is virtually non-existent. And I just have to ask myself, we really do look at the federal government is complicit in this trafficking arrangement that basically has been enabled. So I support Judge Hannah's decision. I think it was the correct decision. If I may, I mean, you're both lawyers and I'm not. I'm just a simple country doctor. But the case before us is his restraining order on the implementation of the executive order. Is that correct?
My understanding, Dr. Burgess, is that the president's action was enjoined by the district court judge, and the administration sought an appeal or a reversal of that enjoinment, and both were denied by the Fifth Circuit.
That's correct.
But the specifics of the policy encompassed by the executive order, those actually weren't the subject, as I read Judge Hannon's order, those were not the subject of the district judge's order. Is that correct?
My reading is that he focused on the rulemaking process and the Administrative Procedures Act as opposed to reaching the constitutional questions. But in his defense, I think judges avoid reaching constitutional questions if they can do so.
And it's interesting that you mentioned the Administrative Procedures Act. I mean, why would that be important that the administration follow that?
Well, it's the law, and the public has the right to provide public comment and input on proposed rules and regulations.
And by moving along as the administration proposed, the public comment part of the rulemaking episode was deleted.
That is the argument of the plaintiffs. And of course, that alone is not sufficient. You also have to allege and offer some proof of an injury. And my understanding of the district court's opinion is both of those were met.
If I may, a counterpoint of view, it's never been the case that the Administrative Procedures Act comes into play for discretionary actions relative to non-prosecution, which is inherent in any prosecution. I mean, as Justice Roberts said in the Arizona case, the discretion granted to the executive is a question of whether it makes sense to pursue removal at all. That is discretion that is not properly the subject of the Administrative Procedures Act. But of course, the discussion in the country has gone far beyond the district judge's decision. And as we know, the court asked to be briefed on the take care clause itself. So that will, I think, be before the court at their request.
I would never disagree with a law professor, and I don't, Dr. Burgess, but I would say prosecutorial discretion is half of the equation. The other half of the equation is the conference of affirmative benefits, which would be reviewable. The exercise or lack thereof of prosecutorial discretion probably is a constitutional question. Whether or not the conference of benefits, which the president also did, that would implicate the APA, as I understand it.
And just to remind people, those specific benefits that were conferred by the president's action?
Work authorization and lawful presence is my understanding, but I stand to be corrected if I'm wrong.
If I could offer a
Let me
counterpoint
just,
of view.
I will offer an observation, and that would include the issuance of driver's licenses to all of those individuals, because did that not occur under deferred action for childhood arrivals?
It did, and I think my understanding was, well, Texas can raise the fees, but the raising of the fee would also be an injury. So I think, you know, you got to be kind of consistent, and when it comes to imposing obligations on the states, we have to have some jurisprudential consistency, and we can't just simply tell Texas, we'll go raise the driver's license fees to make up for this.
If I could, Dr. Burgess, no state is required to provide state driver's licenses to those who are in a deferred action status. That is a choice that Texas made, and it's a state that a decision that many states have made. It's important to note that the benefit provided under prosecutorial discretion is temporary and revocable at any time. It's a lack of removal. It doesn't provide permanent residence or any official status. And I would note that the authorization for work is a delegation to the executive branch. In 1981, the Reagan administration published the rule codifying the longstanding administrative practice of granting work authorization to those who are in deferred action status. And in 1986, the Congress codified that by explicitly delegating that decision to the Attorney General, now the Secretary of Homeland Security. So that's not something made up. It's something that Congress delegated to the executive branch.
Well, it is, I think, important to note, and Mr. Chairman, thank you for being so generous with the time, and I'll yield back because I know there are other people that want to comment on this. But the fact, as you note, that that is a temporary arrangement and could be revoked by another executive in another administration, and certainly is a process that's not lost on the people in the state that I represent. Thank you, Mr. Chairman.
Gentleman, yields back his time. Thank you very much. Judge Hastings, do you seek time?
Yes, Mr.
Gentleman's recognized.
Thank you very much.
Yes, sir.
Mr. Chairman. I'll try to be brief, but I would like to ask Ms. Lofgren if you would tell us a little bit more about some of the organizations and experts who filed their own amici briefs supporting the administration position alongside the brief that you led and signed by 223 members of the House and Senate.
Certainly, a number of law enforcement organizations, as well as individual sheriffs and police chiefs, filed briefs supporting the president's action, including the Major City Chiefs Association, the Police Executive Research Forum, the National Organization of Black Law Enforcement Executives, and 51 current and retired sheriffs and police chiefs from 23 different states. 16 states, as well as the District of Columbia, filed briefs rebutting Texas's argument that the guidance would injure states, and the 116 cities and counties from 35 states representing 55 million people joined the U.S. Conference of Mayors, which represents more than 1,400 cities, as well as the National League of Cities, representing more than 1,900 municipal governments, stating that the enjoined Deferred Action Program protects vital local interess. A number of faith-based organizations, including the U.S. Conference of Catholic Bishops, the Church World Service, the leader of the General Assembly of the Presbyterian Church, the General Synod of the United Church of Christ, the Disciples' Home Ministries, the Mennonite Central Committee, and 17 other religious organizations filed a brief. 45 California business, civic, educational, religious leaders and institutions, including the California Hotel and Lodging Association, the California Restaurant Association, and several chambers of commerces, along with 11 other business leaders, as well as Stanford University, the University of California, and many other distinguished leaders filed a brief. More than 60 business leaders, companies, and organizations, including Mark Zuckerberg and Reid Hoffman, filed to support the president's action. 76 education and children's advocacy organizations filed in support. A brief on behalf of dreamers, young children brought to the United States without their consent, but who lack papers, filed a brief. A number of economists explaining the economic value of what the president did filed. A brief with 330 immigrant rights, civil rights, and labor organizations. A brief by former immigration and DHS officials, both from Democratic and Republican administrations, filed, along with the brief that we've discussed and that Mr. Chairman generously put into the record, signed by 186 members of the House and 39 members of the Senate. I mentioned in my opening statement the 18 bipartisan former members of Congress who filed a brief in support of the action, as well as 2 former INS commissioners, one from a Republican administration and one from a Democratic administration, as well as scholars who filed. And I think it's overwhelming, actually, the support that this action has gotten. I'll just speak as a Californian, talking to the Speaker of the California Assembly just a few weeks ago. California expects to lose a large amount of money because of what a Texas court did in joining the state of California. They are victims of this, and they have filed with the court to say so.
Thank you very much, Ms. Lofgren. I'm pretty sure that my friend, Mr. Gowdy, also has persons who stood with the petitioners in this matter. I personally feel that when the Senate passed a comprehensive immigration reform package with a bipartisan vote, I don't recall what it was, but it was at least more than 60 senators. And of course, there were those, all of them being Republicans, that refused or voted to refuse to take it up. And then our House refused to take up that immigration bill. It's sort of like, you know, in the Congressional Black Caucus luncheon today, we agonized greatly, several of us, about the tone of the present campaign, and we brought up the subject of fanning the flames of anti-immigrant anger. How I perceive this, and I do not mean to offend my friends on the other side, but if you take it as offense, then I readily understand. But I believe that this resolution is nothing but an attempt to appeal to the far-right base of the GOP and to play, in the final analysis, on people's fears and prejudices. I would ask the two of you, at least the three of us and other members of this committee being lawyers as well, if we look just at the process alone, the United States District Court did its job in rendering a decision. The appellate court upheld, the Fifth Circuit Court upheld that decision, and the administration sought certiorari before the United States Supreme Court, and it was granted. Now then, all those names that Ms. Lofgren alluded to and put in the record, and those that you may, Mr. Gowdy, put in the record in support of the petitioners is understandable to me. But what I do not understand is why we have to get involved when, in fact, and would both of you agree, that with or without this amicus brief, a decision is likely to be rendered by the United States Supreme Court. Mr. Gowdy?
Well, Congressman, I do agree that the Supreme Court is going to reach a decision with or without the House filing a brief. Where I might part ways with my friend from Florida is I think the House as an institution has every right to assert itself. And if memory serves me correctly, some of this legislation was considered by the House and affirmatively rejected. So why do we exist if we're going to consider a piece of legislation and reject it? And in fairness, people may conclude that that was the wrong conclusion, but that was the conclusion that the House reached. And it is not lost on me that the president waited until after the midterms of his final term in office to do this. It was not done during the 2 years when our colleagues on the other side of the aisle had control over the House and the Senate. And I think you made reference to possible motives for supporting this resolution. And I want to, with all due respect, give you another possible motive. I can tell you the one that drives me. We both saw confessions thrown out of court because an otherwise well-intentioned law enforcement officer did not comply with a full measure of someone's prophylactic Miranda warnings. Mm-hmm. No question, wasn't coerced, no physical injury, just a technical noncompliance. And we both saw search warrants where the fruits of the search warrant were thrown out by a judge using the exclusionary rule because even a well-intentioned police officer didn't check the right box or didn't file the right return. I just happen to think the manner in which we do things matters. So I can tell you I am not motivated by nativism or anti-anything. I just think the way we do things matters every bit as much as what we do. That's my concern.
And I agree with you that it matters how we do things and what we do. How we did this resolution was purely in the hands of the majority, and I'm not quarreling with that prerogative in many respects, but at the very same time, I believe I'm correct that the minority was not consulted with reference to the resolution. And am I correct in that regard?
I can answer that question. I do not believe that they were, but I as a participant in this, saw that the minority presented their own brief.
Yeah, dissenting views.
I'm simply saying they had an opportunity, equal opportunity. And
I understand, but we're taking, look, there are a variety of measures that we might use to check the power of the president. And my friend from South Carolina, I certainly believe you are driven by different forces than other members of your party. And I don't know who brought forth the notion that we should do this. I don't know whether you did, or out of the Judiciary Committee, or some other member. But at any way you look at it, we're here. But there are other tools that we can use to check the executive. We can pass a law and even override presidential vetoes. Congress controls the purse strings and can restrict the president's spending. We can conduct, and you are part of that, and do an admirable job, oversight and investigations. We can confirm and impeach executive branch officials, and I might add also judicial branch of officials. But the Republican-only amicus brief that will be written pursuant to this resolution, in my judgment, will masquerade as the institutional position of the House of Representatives. But the fact is that this is a partisan conflict and really not an institutional one. I don't know about all of the precedent that it would establish, but I do believe that there are things that are absent in the resolution. I don't think the resolution addresses whether or not we're going to round up and deport the dreamers, as some in the majority party have voted in favor of, whether we are going to end the birthright citizenship, as a hearing was held recently by Republicans. Will it use more of these hateful slurs? And I won't go into all of them and who made them, but we all know. Is the resolution going to call for building a wall on the southern border of Mexico? Is it going to call for tearing families with American citizens apart and separating those families from the American children? I heard distinctly the chair, and I understand that we're in an original jurisdiction hearing, and I appreciate both the witnesses' clarity with reference to the positions that they take. But I do want to call into question the use of Article 2, Section 3, and the take care clause. I wish I had time, and I won't even bother you all with it, but I would like to see the language of the founders with reference to their intent in using that term. I've heard it used here in the Rules Committee, not often, but several times, the failure of President Obama to take care to execute the laws. Let me just read into the record the section that this resolution relies upon, and it is Article 2, Section 3. And interestingly, it comes after the potential that the president has to call into both houses to, if he wishes, call them in at another place even, and allow that if they do not agree, that he adjourn this body. It's interesting. I don't think the president is likely to use it. But here is the take care language. And in the Constitution, it says he, one day we're going to say she, probably, and maybe sooner than I. You think sooner, January?
January, next January.
All right, well, but it says now he shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed and shall commission all the officers of the United States. It's really interesting how that construct is there, and I'll take it upon myself to read further to try to understand what the framers' intent was. But it seems that the discussion was had around commissions and appointments. I do have a couple of other questions. The resolution points to General Counsel for the House of Representatives to oversee the amicus brief. Am I right?
I believe that you are, Congress.
All right, that said, General Counsel then, under that same sentence in the resolution, has the power, if he or she chooses, to hire outside counsel.
It says including supervision of any outside counsel providing services, and I would think intrinsic in that would be for compensation, although I don't see the word. I think
It doesn't
that's
say that, it says pro bono,
right.
which suggests to me that whoever brought it up, that it should be done, already has in mind somebody that they're going to ask to undertake this. As we know, lawyers love to be in the mix, and I don't quarrel with it, but it is why something this important should allow for consultation with reference to all sides. With that, I just want to make sure that we understand, and let me say to you, Trey, on a continuing basis, certainly for the last 15 years, both in the majority and the minority, I have agonized as a person that respects this institution about us ceding more and more power to the executive branch of government. I include in that the taking away of our power to do earmarks, which I'm hopeful at some point in the future that it is revisited with a level of transparency that will not allow for any shenanigans by any of us in seeking. But I think all the time, all of us have things in our district that are needed, and now all of that is in the hand of a whole bunch of bureaucrats that most of us don't know and won't even take time to respond to us when we ask them something. And that's under Democrats and Republicans. And that's troubling to me. So I understand where you all are coming from, but I'm not satisfied that the Speaker is put in this position of needing to file an amicus brief for a decision that's going to be made at some point by the United States with the 4-4, or at some point, maybe next year when we get another associate justice. But I would think this decision is going to be rendered or not, and let the appellate court's decision stand at some point in time. It's very troubling, it's very political, and in my judgment, it's wrong. Thank you, Mr. Chairman.
Judge Hastings, thank you very much. Does the gentleman from Georgia seek time? The gentleman, Mr. Woodall.
Thank you, Mr. Chairman.
Gentleman's recognized.
I'd ask Ms. Lofgren, piggybacking on what my friend from Florida said. I was just reading an article from 2006 where Arlen Specter was dragging the Bush administration up before the Senate, challenging the notion that the Bush administration could simply decide which laws it was going to enforce and which ones it was not. To the degree that what we do here looks like partisan chicanery, it will not have the impact that any of us want it to have. To the degree that what we do here looks like a very serious and thoughtful effort to say the process matters, and we will stand for our process. If we can't do it through the powers of the purse, we'll pursue it through Article 3. I noticed that you have offered an amendment in the nature of a substitute, saying let's do exactly what we're doing, but let's just do it on behalf of the petitioners instead of the other way around. I thought my friend from Florida was questioning whether or not we should play this role as Congress in general, or whether we should just let the process go on, as he asked Mr. Gowdy. Based on your amendment, you appear to believe getting involved in the process is an appropriate step to take. If not, if you and I are not going to agree on which side of this particular case we should be on, would we agree that there is a role for Congress to stand against the executive in front of an Article 3 court to bring that power that Mr. Hastings noted had eroded down Pennsylvania Avenue back to the top of Capitol Hill?
Well, correct me if I'm wrong, but my recollection relative to Senator Specter's admonition of the Bush administration had to do with signing statements, and which I think is completely different than the matter before us. In fact, we have delegated, we, the Congress, have delegated this authority to the executive, starting in 1952, reiterating again in 2002. They have done exactly what we said they should do. So that's quite a different matter than the signing statements where the executive says he's not going to carry out a law because he believes it's unconstitutional. In the case of our brief, we filed this. I spent a lot of time on it. We went to the Ethics Committee because you can't accept volunteer services unless they've cleared the whole thing. They did that. Every member who signed this read it. And I think it's quite a different matter than the resolution that will, I assume, will be put before the House. If you voted for this, you have no idea what the arguments are. I mean, this is, we've said as a body that we're not going to vote on a bill unless it's been posted for several hours, a couple of days, so that people can read and see what they're voting on. Members who have this resolution before them tomorrow will not have the benefit of that. Now, the resolution I've suggested as an alternative, and frankly, I would not have suggested it had your resolution not been before you, but it is, not only has two benefits. One, as a matter of law, it's correct, but two, members know what they're voting on. Because this is a public document, it's been made a part of this record, it's been filed at the court for over a week, and people can see, do they agree or do they not agree? It's not a pig in a poke like the resolution that is before you.
I comment to folks who expressed to me they're concerned about a Donald Trump presidency, that he may be the only candidate in the race who can bring Republicans and Democrats together to stand up for Article 1 once again. It is not just troubling to me that we're having to take this role to rein in the president. Yes, your substitute is actually a defense of the role that the president has taken to implement policy that, as Mr. Gowdy pointed out, we have affirmatively rejected here in this institution.
If I may, Mr. Wood,
Be happy
to. And I'm sure Mr. Gowdy will confirm that we work very collaboratively together and respectfully together, but I do disagree with his categorization in that case, because the fact that a body failed to take an action does not override a law that was previously enacted by the Congress. In 2002, we tasked the Secretary of Homeland Security to prioritize the removal procedures, the policies and procedures. He did that. The fact that we failed to act does not override the law that we passed and the President signed into law, President Bush, in 2002.
I am hopeful that sooner rather than later, we will find that way in the same collaborative spirit in which you and Mr. Gowdy work to stand side by side. Here I'm often reminded of what went on in the great state of Florida when our former Rules Committee colleague, Daniel Webster, was the first Republican Speaker of that House. He had a one-vote majority in that institution, and he overrode Democratic governor veto after Democratic governor veto after Democratic governor veto because they produced a legislative work product, and they stood by it against an executive who thought that he knew better. I want that for us, and I'm grateful to you all for being here today. Mr. Chairman, I yield back.
Thank you very much. Gentleman yields back his time. Gentleman from Colorado.
Well, I'm not an attorney, so, but I hear from a lot of folks in my district on this issue. I can say that when DACA went through, we were able to be part of having clinics across Colorado in our district, and it's made such a difference in the lives of so many young people that I got to know. And we were very excited about DAPA, and we had great plans and a lot of nonprofits in Colorado to help work with parents of American children. And these kids in my district, they come home every day from school worrying that, just if their mom or dad had a taillight out or sped or their workplace was raided, they might be in detention. I visited the detention facility in Aurora several times, ICE detention facility. Many people are also put in county jails in our state, even worse conditions than the private detention facility. It's my understanding the cost of taxpayers is on the order of $120 a night or more for these various detentions. And, there's presumably millions of people that stand to benefit from DAPA. I don't know the exact number, but I think it's in the millions. It could be 2, 3, 4 million. I think absent DAPA, absent enforcement priorities, it's my understanding that they would all be given, be nominally subject to deportation kind of on an equal basis without establishing the clear priorities that it seems like it makes sense. So, I guess my question to Ms. Lofgren is, it's my understanding Congress has provided the funding for something like 40,000 beds or so. Is there any realistic way that any chief executive, forget about President Obama, let's say it was a president that actually wanted to enforce that law, look, if I was president, I wouldn't want to enforce that law, but let's say it was a president that really wanted to deport 11 million people, a president that really wanted to do that. Has Congress given the executive branch the ability to detain or to deport anything close to the number of people we're talking about?
Well, I think your question answers itself, Mr. Polis, because if you have 11 million people in an undocumented status, and I think it's 35,000 beds that must be maintained, clearly you could not put 11 million people in 39,000 beds. But beyond that, it costs money to detain people, to process them, and to deport them. And I'm advised by those who've looked at the budget that less than 4% of what would be necessary to actually deport all the individuals in the United States in an undocumented status is what Congress has provided, which is why I believe, that's not a new thing, in 2002, Congress, in the creation of the Homeland Security Act, directed the Secretary of Homeland Security to establish the policies and priorities for who, in fact, would be removed, noting that not everyone would be. And that's exactly what he did.
Mm-hmm. So, and it's to my understanding, it's not like those beds are empty. They are filled with somebody who has violated our immigration laws, and it's a question of who. And I think certainly Congress could weigh in with guidance on that. Congress has not. All a president can do, any president, a president who wants to deport nobody, or a president who wants to deport 11 million, or a president who wants to deport somewhere in between. Somehow, who fills up those 40,000 beds has to be determined. And it certainly seems to me it should be done in a reasonable and logical way by establishing priorities rather than, I don't know, what's the alternative? Randomly, Ms. Lofgren? If there's not priorities, is it just kind of random who fills those beds?
Well, I think that is the issue here before us. That, and in fact, the setting of priorities has not been enjoined by the court. It's the DACA and DAPA that have been enjoined. And the idea that you would have priorities, but you would keep them secret and not allow people to know what they are is not rational, nor is it required by the law. Yes, those beds are for the most part filled, and they're filled. I don't have the memo before me, but my memory is that priority 1 is primarily people who committed serious crimes, terrorists, and the like. Priority 2 are people who've had a serious misdemeanor, recent entrance, and it's those categories of individuals who have been apprehended and who are being removed on a priority basis. We remove somewhere between 700 and 1,000 individuals each and every day through our ICE system. So it's not as if plenty of people aren't being deported. It's a question of who.
What is the timeline for this case, Ms. Lofgren? When are we expecting?
It's being argued next month, and the expectation is, although you never know with the court, that we would have a decision in June.
And what is this? I understand. We have people that have gotten I think 3-year DACA is the renewal, if I'm not mistaken. What is the status of that if there's a president elected in this country who terminates the program? Is that term of 3 years honored, or would
Well,
those
it's
be
a
canceled
two-year-
prior to?
It's a
or the
2
2
years,
yeah.
and the expanded DACA, part of the provision that's been enjoined was to extend that to 3 years.
That's right.
That is on hold. But the fact is, since this is a discretionary action, even though there is a piece of paper in a work authorization, those are revocable, whether or not you've got a 2-year term, because this
They're
is
revocable or irrevocable?
They are revocable.
They are revocable.
By the chief executive, because they're.
So that makes it's very important we elect the right woman president, then, right?
I personally agree. But, you know, this is.
says Trump would protect us better.
This is an exercise in judicial of judgment in prosecution. We could get into a fine argument if, for example, Congress decided to appropriate $600 billion a year to remove everyone. You could argue as a legal matter, you really wouldn't have prosecutorial
That's correct.
discretion because
Right.
the tools had been provided to remove everyone.
correct.
Since we have not done so, you have prosecutorial discretion. That decision, since it is vested in the executive, can change depending.
I mean, isn't
on
it,
the
I
policies.
mean, given that the Republican majority does the appropriation, sets the budget, haven't they basically given that discretion to the executive by failing to give the executive the resources to enforce our
Well,
law
I would
fully?
say, we never want to say it's the Congress of the United States that acts as a body.
What's that? It's the Congress of the United States, that's correct. Not that I voted for it, but yes, it was a Congress of the United States that basically has required, is that too strong a word, the president to use some form of executive authority, given that they've not given the president the
Given that
ability
we
to
have not
enforce the law?
appropriated sufficient funds to remove everyone, obviously, not everyone is going to be removed. And the question is, how is that going to be dealt with? We directed in 2002 the secretary to establish the priorities and policies for who should be first, and that's what happened here.
Well, you know, and I thank you for your update as well on the timing, because I have to, you know, talk to families every day, and like many offices, we do a lot of casework with, you know, families with American kids and the moms in detention or the dads in detention, and, you know, and we keep assuring them that hopefully something will happen soon. But it sounds like they have a lot at stake in this presidential election, given that this permission is revocable. They eagerly await the outcome of this court decision, which would extend DACA to 3 years, even though it's only extended if there's a president that continues it, and would establish DAPA. Very important. These are the parents of American children that we're talking about. So again, I just find it, again, as a non-attorney observing this, it just seems very bizarre that it's Congress's own lack of action that has essentially forced a president to establish some kind of discretion and prioritization in this area. And then once he's done so, Congress is saying, we didn't give you the authority to do that. But it was Congress that failed to give the president the ability, or anything close to the ability, to enforce the law. I mean, we're not talking, they gave him 90% of the money. We're talking they gave him like 2% of the money. I mean, whatever it is, they gave him nothing. I mean, there's nothing close to the money it would take to enforce the law. And that's Congress's fault. If Congress did give the president that authority, and it would be a totally different legal discussion about the establishment of prioritization. But any executive has to do that, just as haven't other presidents done this, Ms. Lofgren?
Yes, that has happened. I would note, however, that in the most recent decision in the Justice Roberts' opinion on the Arizona case, they actually didn't tie the exercise of discretion to the appropriations, because there can be foreign policy reasons on why you might not remove someone. For example, let's say you've got someone who is undocumented from North Korea, and they don't meet the criteria for asylum. They're here undocumented. Let's say you had all the money you needed to remove them, but you might make a decision for foreign policy reasons not to do that. So the exercise of discretion has been used historically on many occasions, both because of prosecutorial discretion and appropriations, but also for foreign policy reasons, for humanitarian reasons, and
But
the like.
and there could very well be many legal arguments, but the appropriations one seems pretty big, because again, we're not even talking something close. I mean, you're talking like 35,000 beds, and you're talking 11 million people. I don't know how many, 10 million, 12 million. I mean, you're talking well beyond an order of magnitude there. I mean, you need a lot more beds. You need a lot more expenditures. And Congress hasn't even talked about that. I mean, maybe they talk about 1,000, 2,000 more beds here or there, but I mean, you're not even close to it. So it doesn't, for that particular issue, any president needs to use their prosecutorial discretion. President Obama did. You may not like the way he used it. That's fine. Elect a different president. They'll use it differently. But any president's going to need to use it, because there's no way a president can enforce the law with the resources that you're giving them in this area. Not to mention the other legal arguments that Ms. Lofgren mentioned, which could very well be valid legally. I'm not an attorney. I just know basic economics, and I know that 35,000 beds doesn't get you very far for 11 million people. I don't need to be an attorney to know that. I hope that this gets, the DACA and DAPA case here gets resolved quickly through the courts, because we need to give these American families, and again, they're of mixed status. We're talking about families with American children, as American as my kids, your kids. I mean, we need to get it resolved, because we have a stake in a country in the success of these American kids. I mean, we're educating them in our schools. They're going to be voters. I wonder who they're going to vote for someday. Are they going to vote for somebody who deported their mom, or are they going to vote for somebody who helped their family stay together? I'm just, curious about that. It's something we all, might ponder, as well as the kids are, of course, already American citizens. Many of them already turning 18. Many of them already voting. I hope that we can give them the certainty they need that their families will be together under the law, and that is the great, that is the value of our nation. We believe in families. I believe in families, and I'm confident that the courts will believe in families, and they will throw out this anti-family amicus brief that is being proposed under this bill. And I yield back.
Thank you very much. I would note to the gentleman that at the time what was known as the influx of children that came to us, that the Department of Homeland Security had an extra $500 million left to begin paying for the process. So it's not like they were in need of a lot of money.
Will the gentleman yield for a moment?
I would.
I believe, again, I'm not an attorney here, I believe the influx of children on our southern border is a different issue than the DACA and DAPA case.
All I'm suggesting to the gentleman is the department found the money to take care of something that was not included in the original plan for the year. The president had an extra $500 million that he shifted to that. So if the issue is the extreme lack of money that you're arguing, I fail to see where that's a reality.
And the final point I make is it's not on order of a few hundred million. You're talking about a lot more money here.
Well, this is not a hearing for us to figure out the border problems, but I would welcome that opportunity at some point as we bring our witnesses in for appropriations. And I appreciate the gentleman very much. Thank you very much. The gentleman from Ohio, do you seek time?
Yes, sir.
Gentleman's recognized.
Thank you, Mr. Chairman. I'll be fairly brief. Appreciate you both being here. You're both distinguished attorneys. You seem to have a disagreement. Our founding fathers put forward a system when there's a disagreement between the executive and legislative branches, and the executive branch and other citizens who feel aggrieved or have a problem as a result of an action of the federal government, and that's the courts. So this legitimately is something that should be decided in the courts. I would like to ask Chairman Gowdy, you alluded to this, but I'd like you to sort of expand on it a little bit. Can you talk about the slippery slope of not following the law today and tomorrow and what it could mean to all of us? Today, the other side of the aisle is really happy that the president isn't following the law because politically it's something that benefits them. What's next?
Congressman, that is my great fear. And I have told, look, every one of us is sympathetic when a child comes up to us outside the judiciary room, which they do from time to time, and tell us the circumstances of their life. I don't know a single person who would not be sympathetic with that. On the other hand, next week, next month, next year, you may feel the need to have the law fully enforced. And if you cannot rely on the law, which is the most unifying, equalizing force we have in our culture, if you cannot rely on it, then what's the use in having it? And I listened when my friend from Colorado was talking, and certain points he made I frankly agree with, but I can tell you this as a former prosecutor, no category of criminal enforcement is fully funded. We didn't fully fund embezzlements. We didn't fully fund every single cocaine powder case, every single heroin case. But I don't recall a single United States attorney announcing ahead of time that if you only steal this amount of money from a bank, you won't be prosecuted. I mean, that is so antithetical to prosecutorial discretion.
Will the gentleman yield for a moment on that?
Sure.
Oh, of course. Yeah.
Well, and that's why I'm not trying to pick a fight with the gentleman from Colorado. I'm just simply pointing out there is no category that is fully funded. So you have to use prosecutorial discretion. But prosecutorial discretion is used episodically. You do not announce ahead of time broad categories of noncompliance because at a certain point that begins to look more like anarchy than the episodic use of prosecutorial discretion.
And I will yield to my friend from Colorado.
Thank you, gentlemen. When Mr. Gowdy was mentioning, we don't fully fund, for instance, the FBI to investigate fraud. I mean, we see this prosecutorial discretion because we've had cases where people get defrauded, over email or phones of $8,000, $11,000, and the response we always get is, "Oh, sorry, the FBI doesn't do it unless it's more than," and I don't remember the amount, 20, 40, 50,000, something like that. So they use that discretion in that way. Doesn't mean I like it, but obviously, again, they're not funded to investigate every crime like that. So that's a similar instance of the discretion. I'm happy to yield back.
Reclaiming my time, Mr. Gowdy, Chairman Gowdy. But the FBI doesn't publish ahead of time how much you can take, and it's okay, do they?
And that was my point. We don't alert people that as long as you do it this way, there are not going to be any consequences for your actions. In fact, I don't think any United States Attorney's Office would dare let the public or the criminal defense bar know these are our declination levels. This is all internal. So to announce ahead of time, I get the priority part of it. Although I will tell my friend, I did ask an administration witness, if we fully funded this, if we fully funded it, would you apply the law? And the answer was no.
Right.
So
it's not about appropriations.
Yeah, it can't simply be about appropriations or something else going on.
No, it's not about appropriations. And I appreciate both of your statements. You are smart attorneys. Like I said, you have a legitimate disagreement. And and the courts are the ones who are supposed to sort that out. And Ms. Lofgren, you talked about all these great Americans who have, filed amicus briefs in this suit. Why would you want to stifle the Congress of the United States and its will to do the same thing? That's what I don't understand here.
Well, I've got a couple of issues with what's before you. First, no one would know specifically what's going to be filed, and I think that's problematic. I think that members are being asked to vote on something that they don't know what it is, and that's contrary to what we said we would do as a Congress. As has been noted, I led an effort to file an amicus brief that many members of Congress signed on to. Certainly, people who disagreed with that point of view had the same right to do that. I respect that. That's
But
different.
aren't you speaking against their right? Help me understand.
No, I'm not.
Okay.
What I'm suggesting is to make this an official action of the House of Representatives when we are quite obviously divided, as you have noticed, is not an appropriate thing to do. And in fact, it's almost never been done.
But in this House, doesn't the majority rule every day? When you were in the majority, you ruled?
We did not bring up a resolution to do an amicus brief. We asked the Congressional Research Service to research when the last time this was done. This is a very rare procedure for a reason. It puts the House on one side when, in fact, the House is dramatically divided. I can only assume that maybe the Republicans didn't get organized in time to go through the process that we went through, going to the Ethics Committee, writing it, reviewing it, going one by one to the members and asking them to sign. It's a lot of work. I think that had the Republican members gone through that work, they would have had every right to file a brief. I think what this procedure is not the right way to proceed.
Thank you. So we deal with difficult decisions every day, and I will tell you, I have sympathy for the position of many of the folks who are in very difficult positions who have, American-born babies that the parents got here illegally, and I understand that Congress has a job to do. In fact, we have under Article 1, Section 8, a job to do with regard to immigration naturalization laws, and we need to do it, and we need to do the tough work. But the other thing we need to do, and my friend from Florida spoke about it, there's been a constant attack on Article 1 of the Constitution, the legislative authority of this body, from Republican administrations, from Democrat administrations, and a ceding of authority under Republican Congresses and Democrat Congresses. It's bad for our republic. And it is, for me, this isn't about immigration. This is about Article 1. This is about who makes the laws. When I talk to fourth graders, I tell fourth graders, the legislature, the Congress, makes the laws. The executive branch carries out the laws, and the judicial branch interprets the laws. We all know it's frankly a lot more complicated than that because there are hundreds of agencies that can make the laws through agency rules, but they use the Administrative Procedures Act. But our founding fathers set up a system of checks and balances. Those did not happen here. There was no due process. It's not about the subject before us. It's about the issue before us. The issue is about who's going to make the laws in this country. And that's why I really do think we need to do this. I have sympathy for the position of the minority on the human cost and toll with regard to many of these folks who are in difficult situations. And we need to do our job on immigration. I recognize that. But we can't cede our authority under Article 1, then we won't have a republic. It goes back to my first question about the slippery slope of not following the laws. When you don't follow the law, pretty soon you don't have the law. It's gone because you can't count on it anymore. And that's what this is about. And so I understand it's been a lot of discussion about immigration because that happens to be the topic, but it's not the real subject here. The subject is about who's going to make the laws in this country, and that's why this is so important. And I know it's an extraordinary circumstance, and that's why it's come to this over 40 years, sadly, and we need to stand up for Article 1 of the Constitution, and today's the day. I yield back, Mr. Chairman.
Chair thanks the gentleman, notes that his pastor is waiting for him in the hall, and we're all anxious for you to connect with your clergy. Chair recognizes Mr. Byrne.
Thank you, Mr. Chairman. Mr. Getty, let me ask you some clarifying questions. I understood what you said earlier was that the federal district court, when it entered the original injunction, did so on the basis of the Administrative Procedure Act. But it's my understanding that in the appeal to the Supreme Court has designated one of the issues before it to be the constitutional issue. Is that your understanding as well?
Yes, sir, it is.
So it's appropriate for anyone who's filing an amicus to address the constitutional issue under any other amicus determination?
Congressman, I would think not only is it appropriate, but it's the Speaker of the House speaking on behalf of the institution. You and I would not have standing as individual members of the House, but the institution as a whole does. And I think in a circumstance like this, where it's a constitutional equilibrium argument, he has an obligation to do so.
Okay, and that was, you've gotten to my next question, and I'm glad you did so, because what you're saying is that there are certain unique situations where the prerogatives and power of the Article I branch of government have been usurped by the Article II branch of government, that it's incumbent upon the body corporate, in this case being the House of Representatives, to, in essence, push back, say, no, that's not your authority, that's our authority. You think it's incumbent upon us to do that corporately?
I think we have to, Congressman, and I think some of the things that are suggested to us from time to time, frankly, are punishments for not complying with the law. When what you seek is the remedy of the actual enforcement of the law, then this really is the only mechanism you have. Impeachment's a punishment. Appropriations is a punishment. We want you to follow the law. This is the only remedy we have.
And is there any other basis, you said two, but are there any other basis to obtain what you just said other than a resolution by the House as a corporate body?
I'm trying to think back to Raines versus Byrd. I don't think the Speaker would have the standing to do it as the, quote, representative of the institution. I'm quite certain that you and Congressman Woodall and others would not have standing as individual members, but the injury was to the institution itself. So the institution itself needs to speak.
And that's why there's a resolution by the House and not an amicus by this part of the House or that part of the House.
Yes, sir.
Okay. Now, reading the Constitution. When I went to con law in law school, they made us read the Constitution. They made us read some of the cases that interpret the Constitution, but when we had to take our exam, we had to know the Constitution. And Article I, Section 8 says the Congress shall have power, and it lays out several, and here's one of the powers, to establish a uniform rule of naturalization. I just quoted it word for word. Now, if you flip over to Article 2, which gives the powers of the President, it says absolutely not one thing about the President having such power. Now, I was listening to Judge Hastings. I thought he made an interesting point there where he says, I wonder what the Founding Fathers, how they would have interpreted Article 3 that says that the President shall take care that the laws be faithfully executed. My memory of what happened in just reading the journals from the Constitutional Convention were that they didn't talk about Article 2 very much, because the powers were left, the big powers were all put in the Congress. So there may be something there. My aide over here is going to take a look at see what he can find. But there is an instance where one of the most important founders actually did have to do this, and that's General Washington, or I should say President Washington. But in this particular instance, he was serving both as President and General. He read the clause as imposing on him a unique duty to ensure the execution of a federal law he personally opposed. And that was the law that gave rise to the Whiskey Tax Rebellion. President Washington observed, quote, "It is my duty to see the laws executed. To permit them to be trampled upon with impunity would be repugnant to that duty." So while I don't know of anything from the Constitutional Convention itself, President Washington, who chaired the Constitutional Convention, certainly had what I think would be the common sense understanding of that obligation, which is you're supposed to execute the law as they are written. Would that be your understanding as well?
Yes, sir, Congressman, and I can't help but note, as you have also noted, the use of the adverb faithfully has to mean something. It was not enough to the framers that they simply said you have to take care that the laws be executed. They added the word faithfully, and they had to do so for a reason.
Absolutely. Now, there was a decision, and I know Ms. Lofgren knows all about this because she's an immigration specialist, from 1952 in a case called Harry-Ciades versus Shaughnessy. There was a concurring opinion by Justice Frankfurter. I think we all recognize Justice Frankfurter as a Franklin Roosevelt appointee, and certainly one of the intellectual giants of the Supreme Court. Ms. Lofgren, you'd agree with that, I would assume.
Perhaps.
Oh, you do not think that
No, I don't want to get into an argument.
You don't think Justice Frankfurter is...
No, he was a distinguished jurist.
Yeah. Let me read to you a quote from that decision from Justice Frankfurter. "The conditions for entry of every alien, the particular classes of aliens that shall be not denied entry altogether, the basis for determining such classification, the right to terminate hospitality to aliens, and the grounds on which such determination shall be based have been recognized as matters solely for the responsibility of the Congress." Do you disagree with Justice Frankfurter's statement there, Ms. Lofgren?
Well, certainly in the Constitution, I don't have my little booklet, but I have my Constitution app. It is the legislative branch that devises the laws of naturalization and therefore entry. However, I would note in the case before us and subsequent to the case that you were citing, Congress has repeatedly delegated to the administration, to the executive branch, the power to make distinctions and to provide for temporary relief from removal. And it is that authority that has been delegated to the executive that is being utilized in this case. I would note also that it was during the Reagan administration and then later in 1986 during IRCA that the specific grant of employment authorization for those who are in a deferred action status, that was what the Congress adopted in law, that could be provided by the Attorney General and now, by extension, the Secretary of Homeland Security.
But that power is not unlimited. You're not saying that's an unlimited power, are you?
I'm saying that the Congress delegated to the executive branch to do what the executive branch has done here. Now, if
I'll
we
ask
don't
Mr.
like,
Gowdy that question.
we
Is that
don't
an
like-
unlimited power?
Well, it can't be because that would be anarchy. And what I was thinking, Congressman, while you were having a conversation with my friend from California, is if Congress delegates a power, then Congress can claw that power back. And it would be absurd for us to have to ask the chief executive for permission to claw back a power that we had in the first instance, which seems to be what our friends on the other side of the aisle are arguing, is that you have to pass a law to reassert what you had in the first place, which means the executive branch gets to weigh in on whether or not we reclaim an original power.
Well, it seems to me that the president does not think that his powers are unlimited. In fact, it seems to me the president recognized on March 28 of 2011 that he's got very limited powers here. He says this, or said this, 5 years ago, quote, "There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system that for me to simply, through executive order, ignore those constitutional mandates would not conform with my appropriate role as president." So it seems to me the president, and there's 21 other instances where he said something like that, the president has teed up their own constitutional argument against him. And we would not be fulfilling our duty were we not, as a body corporate, taking our position as one of the co-equal branches of government to the Supreme Court and saying this is our power, not his power. So I appreciate the argument we've had here today. It's been interesting. But it seems to me that this is precisely what we should be doing. And I don't know what the outcome's going to be. It's interesting to look at some of the wording of the Supreme Court so far on these issues, but I don't know what it's going to be. I do know that we talk about this in the context of an immigration decision or executive action taken by this president. This president's not going to be around in 9 months. There's going to be a different president. So I wonder what my colleagues on the other side would think if we had an executive order by President Trump on immigration laws that you disagree with in terms of the extent of his power, whether my friends on the other side would think it would not be appropriate to have some sort of judicial position or position in court to push back on that to guard our Article I powers against what we think, we believe corporately, is an inappropriate use of that power. Sometimes we start talking about these decisions in the specific context, and we forget the precedent we're setting. And there is a very dangerous precedent set here. And then another time in this room, we talked about this. And what I said is what worried me is exactly what you pointed out, Mr. Gowdy, and that is that we're going to say we're not going to enforce a whole category of law. Imagine any president coming forward and saying, during my administration, we're not going to enforce the Clean Air Act. Just not going to enforce it. Got limited money out there. I get to pick what we enforce, what we don't enforce. My friends on the other side would justifiably be outraged. I would be outraged. Well, I think we need to be thinking about something a lot bigger than just this immigration issue that's before us. Because if we don't start doing something now, there's going to be another president down the road that's going to take it to another extent, and then another extent, and one day we're going to wake up, and there might as well not be a Congress of the United States. We might as well let the president run the country. And that's not what the Founding Fathers meant. I know this much from reading the journals of the Constitutional Convention. They wanted to stop a despot from being able to do that. They lived under a despot named King George III, and they despised it. And they wanted a form of government that limited itself so it wouldn't happen again. And for us not to push back in this instance is to go in the face of what we have been bequeathed, which is a government constrained by a Constitution with clear limits in it. I am a child of immigrants. Everybody in this room is a child of immigrants. I love the fact that we are a pluralistic society. And that's not what we're here today to talk about. If you want to talk about that, we'll talk about it another time. Today, we should be united, pushing back against an executive out of control. I appreciate the resolution. I think it is perfectly in order, and I'm glad this committee has had an opportunity to talk about it in substance, and I yield back.
Mr. McGovern, do you seek time?
Just briefly.
Yes, sir. Gentleman's right.
I just want to thank you both for being here. I just wanted to make one observation. We're not here fulfilling our duties. This is not what we're doing here today. In fact, we're very good about doing everything but our job here in the Congress. The gentleman, Mr. Stivers, mentioned before that the majority rules. I wish that were the case. What we should have done a long time ago is pass the Comprehensive Immigration Reform Bill, and the United States Senate actually did it, bipartisan vote. 14 Republicans voted for it, and we were not even given the opportunity to even have that bill brought to the floor so there could be an up or down vote. And part of the reason why is because if it was brought before the House and there was an up or down vote, the majority would have ruled and it would have passed. And we would have a very different discussion right now. I support what the President has done. I think that it is clearly within his authority. And I think the President would have preferred us to do our job. But here's the deal. This place is proven incapable of dealing with this issue. And I get it. The base that some of my colleagues represent don't want to deal with this issue. But the fact of the matter is it's not going away. At some point, we're going to have to figure out how to fix our immigration laws. And it has to be more than doing nothing. And then when the President uses his legitimate discretionary authority, we all have this, meltdown, and we're going to file briefs, and we're going to bring suits, and how about just do our job? I think if we did our job, we wouldn't even be here today. So, I don't want to prolong this any more than it already has been prolonged. I don't think this is a serious way to approach our immigration laws. You can all give your speeches, but I don't think it amounts to very much. I think people see right through this, and you've got the votes here to pass it, so go ahead and do it, and I yield to the gentlelady.
I just wanted, Mr. Byrne, I guess he had to leave, but asked a question of how would we feel if President Trump decides to use the authority that the Congress has delegated to him to focus on deporting children and their mothers only. I would object to that as a moral matter, but it would be within the parameters of what Congress has delegated to the executive branch. if we object to the use of the power we have delegated, we ought to look in the mirror and say, should we delegate this authority? We've done it for a reason, because it's impossible to manage this complex system otherwise. And we're focused on the undocumented individuals today, and rightly so, because that's so much in our minds. But let's remember that the authority to defer deportation has been used repeatedly for foreign policy reasons. When there is war, when there is a natural disaster, for foreign policy reasons with our allies, we have deferred deportation repeatedly for hundreds of thousands of people over many decades. So this is not a new authority. It has been delegated to the executive, and I would hope that if, I don't believe that Mr. Trump will become president, if he does, he might.
I'll probably be deported.
He might, well, you would have a defense, sir.
Sure.
But he'll file a brief to protect you. But no, the priorities are to be set by the executive, and that I didn't want to leave that question unanswered, Mr. Byrne.
I thank you both for your time and patience, and I think we've prolonged this enough. And Mr. Chairman, I yield back my time, and let's get this over with.
Gentleman yields back his time. Thank you very much. The gentleman from Washington is recognized. Gentleman does not seek time. Thank you very much. Is there any other member that seeks time? Any other member that seeks time? See none. Thank you very much. I want to thank both of our awesome witnesses for being here, not only provide expert testimony, but really their insight into the ideas surrounding this important legislation. I want to thank you both. If you'll please do make sure that you leave your anything you brought in writing for our awesome stenographer so that she has an opportunity to catch up. This has been a long hearing, and I appreciate your help, and thank you very much.
Thank you, Mr. Chairman.
Is there any other member that seeks to give testimony, HRS 639, 639? Seeing none, this now closes the hearing portion of HRS 639. The committee will now move to its original jurisdiction, markup of HRS 635, authorizing the Speaker to appear as amicus curiae on behalf of the House of Representatives in the matter of the United States versus Texas. Please be advised that I believe that the opening statement that I made in support of not only why we're here, but the reasons of importance still do matter. The President of the United States, we believe, has failed in his duty under Article 2, Section 3 of the Constitution, under the Take Care Clause, be fully executed, and the Supreme Court has specifically indicated that it will consider the plaintiff's claims under the Take Care Clause, and thus, we're here for that simple opportunity. Does the gentlewoman seek any time from New York?
Yes, thank you very much, Mr. Chairman. I move the committee adopt Slaughter Amendment Number 1, which would express the position of the House in support of the Obama administration in U.S. v. Texas. The House Republicans will file an amicus brief pursuant to this resolution, and it will masquerade as expressing the position of the institution of the House of Representatives in an inter-branch separation of powers conflict. But the fact is, this is nothing more than a partisan fight about elections and immigration policies. Democrats in the House, who do represent half of the country, were not consulted, and the Speaker's amicus brief does not speak for the Democrat members of the House. My amendment, in the nature of a substitute, would allow the House to vote on endorsing the amicus brief led by Representative Lofgren, signed by 186 Democrats in the House and 39 Democrat senators, filed on March 8, 2016. It is important to note that this Republican House resolution we're meeting on has no substantive findings and makes no legal arguments against the President's executive actions. We don't even know what legal arguments you are being asked to endorse. You have not written your brief yet, so it would take magic for us to know what's in it. The fact is that President Obama's executive actions on immigration, deferred action for childhood arrivals, known as DACA, and deferred action for parents of Americans and lawful permanent residents, known as DAPA, are common sense lawful exercises of executive discretion consistent with the actions of presidents from both parties over the last half dozen decades. For example, from 1987 to 1990, Presidents Reagan and Bush implemented a, quote, family fairness policy that deferred deportation of an estimated 1 million spouses and children of people who qualify for legal status, a move which we all agreed on. President Obama's actions are no different than those of President Reagan's when he used his discretion to grant work authorization to beneficiaries of the deferred action, a longstanding practice that was later codified by Congress in the 1986 Immigration Reform and Control Act. That is the precedent, and that's the law. If we are going to hold a vote in the House on this resolution, let's hold a vote on endorsing the correct side of the argument. And I ask Mr. Chair and members of the committee that Ms. Lofgren's brief be allowed to be considered tomorrow and when this brief from the administration is discussed.
Thank you very much. You've now heard an opening statement and a motion that the gentlewoman would choose to push to the committee. And I want to thank the gentlewoman for her statement and her motion. Is there further discussion? I think that's right. No further discussion. Thank you very much. Now, what I'm going to do is going to take your opening statement and that which you wish to have a question about. We're not going to have a vote on your amendment that we were considering for a motion. Now I'm going to ask that we read our motion and then allow you an opportunity to come back with an amendment to that. Thank you very much. The chairman now be in receipt of the motion from the gentleman from Georgia.
Mr. Chairman, I move the committee report House Resolution 639 to the House with a favorable recommendation.
I can do it.
Thank you very much. You've now heard the motion from the gentleman from Georgia. Is there amendment to that?
Yes, Mr. Chair, I move the
Gentlewoman
committee.
recognized.
Thank you. I move the committee adopt Slaughter Amendment Number 1, which would express the position of the House in support of the Obama administration in U.S. versus Texas.
Thank you very much. You've now heard the motion and the amendment. Is there further discussion on the amendment? Seeing none, the vote will now be on the Slaughter Amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call, please.
Gentlewoman asks for a roll call vote.
Ms. Fox, Mr. Cole, Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers. No. Mr. Stivers, no. Mr. Collins. No. Mr. Collins, no. Mr. Byrne. No. Mr. Byrne, no. Mr. Newhouse. No. Mr. Newhouse, no. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern.
Aye.
Mr. McGovern, aye. Mr. Hastings. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 7 nays.
The Slaughter Amendment is not agreed to, not agreed to. Further amendment or discussion. The vote will now be on the motion from the gentleman from Georgia. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it.
And we'd like a roll call.
The gentlewoman seeks a roll call vote.
Ms. Fox. Mr. Cole. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Stivers. Aye. Mr. Stivers, aye. Mr. Collins. Aye. Mr. Collins, aye. Mr. Byrne. Aye. Mr. Byrne, aye. Mr. Newhouse. Aye. Mr. Newhouse, aye. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 3 nays.
The motion is agreed to, and accordingly, I will be handling this. I'm sorry, excuse me. The rights of the minority will be maintained to submit their views. And without objection, the committee staff is authorized to make technical and conforming changes to H.Res. 639. So, the motion has been agreed to. We have agreed without objection to make technical changes to the language as necessary. I will be handling this for the majority tomorrow,
And I will handle for
and Mrs. Slaughter will be handling this for the Democrats.
Mr. Polis?
Yes.
Now
Excuse me, Mr. Chair, I made a mistake here. I will be doing the rule. Mr. Polis will be doing the
Excuse me,
resolution.
the gentlewoman is exactly correct here. And we're laying this down like it's a funeral with the preacher reading everything that comes. We are now going to consider the rule. That was the original markup that we were doing. And I will be handling that, once again, for the majority, what will be the original. And now we will move to the rule, and the chair will be in receipt of the motion on the rule.
Thank you, Mr. Chairman. I move the committee grant H-Res 639, authorizing the Speaker to appear as amicus curiae on behalf of the United States House of Representatives in the matter of United States et al. V. Texas et al., a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Rules. The rule waives all points of order against consideration of the resolution. The rule provides that the resolution shall be considered as read and shall not be subject to a demand for division of the question. Finally, the rule provides one motion to recommit.
Thank you very much. You've now heard the motion from the gentleman from Georgia. Is there amendment or discussion of that?
Thank you, yes, Mr. Chairman.
Gentlewoman's recognized.
I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H-Res 639 by Representative Lofgren, Leader Pelosi, and myself and the others, number 1, which would strike the text of the underlying resolution and express a position of the House of Representatives in support of the Obama administration in U.S. v. Texas. Mr. Chair, if we're going to proceed with this resolution at all, the full House should have the opportunity that we just had in our original jurisdiction markup to vote on whether to back the President's executive actions or to oppose them. And even if we disagree on who's right on the law, every member of this House represents over 500,000 citizens, and we should all get a say in which position to take. And I request a yes vote on the amendment.
Thank you very much. Further discussion? Seeing none, the vote will now be on the slaughter amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
I'll need a roll call.
Gentlewoman asks for a roll call vote.
Ms. Fox, Mr. Cole, Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers. No. Mr. Stivers, no. Mr. Collins. No. Mr. Collins, no. Mr. Byrne. No. Mr. Byrne, no. Mr. Newhouse. Mr. Newhouse, no. Ms. Slaughter. Aye. Ms. Slaughter, aye. Mr. McGovern.
Aye.
Mr. McGovern, aye. Mr. Hastings. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 7 nays.
Amendment is not agreed to, not agreed to. Further amendment discussion. Seeing none, now the vote will be on the rule. The motion from the gentleman from Georgia, those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it.
I think we better have a roll call on this.
Gentlewoman asks for a roll call vote.
Ms. Fox, Mr. Cole, Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Stivers. Aye. Mr. Stivers, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Aye. Mr. Byrne, aye. Mr. Newhouse. Aye. Mr. Newhouse, aye. Ms. Slaughter. No. Ms. Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 3 nays.
The motion is agreed to. Accordingly, I will be handling the rule on behalf of Republicans. And Mrs. Slaughter will be handling this for the minority. I want to thank our members for their dedication to today. This ends the hearing, the last final hearing for the week for the Rules Committee. Thank you very much.